purposes of the 995, the court has to find that there is sufficient evidence, a scintilla of evidence, to tie Mr. Shivari to any of the underlying crimes or to the charged crime. And I submit to the court that there is no such evidence. There is evidence that Mr. Shivari is a 5'9" member. There is evidence that Mr. Shivari posted on Facebook words to the effect of Crip Killer and Neighborhood Killer and On Brims and Hitch Old Brimmin. But there's no evidence that anybody saw those posts. There's no evidence that was adduced at the preliminary hearing from every witness that I asked after they spoke about each substantive offense. Do you have any information if Mr. Shivari willfully promoted this crime? Every single one to a T, except for as to count 10, every single witness said no. Do you have any evidence as to whether or not Mr. Shivari willfully furthered this crime? No. Do you have any evidence as to whether Mr. Shivari willfully assisted in this crime? No. Save Detective Collins. Do you have any evidence as to whether Mr. Shivari benefited from this crime? No. So we look at the conspiracy first in count 1, 182. Requires an agreement to commit a specific crime. The people adduced no evidence that Mr. Shivari was involved in any agreement to commit a homicide, an attempted murder, or a robbery. What they're trying to do is bootstrap the Facebook post and say that that is his agreement. Because he had uttered the words Crip Killer and Hitch Old Brimmin, and I do not back down from faith, that is sufficient to prove an agreement. And I submit to the court that is not sufficient for purposes of a preliminary hearing, even on a scintilla of evidence standard. And I'll talk about Facebook in just a minute. Short of count 10, Mr. Shivari's name did not come up by any of the witnesses uttered as to being in that offense or being involved with that offense. Count 10 is the shooting of DeAndre Southall, in which Brandon Orchard is accused and was later prosecuted, I believe, pled guilty to shooting DeAndre Southall, and Miss Miranda White drove him there. The only evidence adduced in the entire preliminary hearing, 1,500 pages of transcript, that Mr. Shivari was at any location was one letter written on August 22nd, over 2 months after that incident, that shooting of DeAndre Southall, in which Miss Miranda White refers to a person as having been with her that night named Little Reesburg. Detective Collins, who is the expert in this case, said that he does not know every single member of 597. I asked him, could there be another Reesburg? He said yes, but he is not aware of any, but there could be. I asked him, did you talk to Brandon Orchard about who this potential other person may be? And he said no. He had already invoked. I asked him, did you talk to Miranda White about who she referred to in her letter? And he said no. I submit to the court that that is not sufficient evidence to hold this man to answer for that crime, because somebody refers to a RESPO, which could be anybody of 200 plus members of 5'9" Brims. Now let's get to Facebook. The way that the prosecution has put their evidence together in this case is they have taken spatterings of statements that were made on Facebook and tried, after the fact, to contort or weave that into a cogent theory that because a statement was made at some point, a month, 2 months, a week, 6 months before, about Crip Killer, that somehow the person who made that statement, in this case Mr. Shivari, on Facebook, had knowledge that a crime was going to occur under 182.5 and willfully promoted that crime. At no instance did they adduce or bring forth any evidence that any one of those postings were specifically tied to any one of the charge offenses under 182.5. In fact, I even asked Detective Collins, who obtained all of the Facebook evidence by way of subpoena, does Mr. Shivari have any known West Coast Crip or neighborhood Crip gang members on his friends list? He said he didn't know. So if the prosecution's theory is that Mr. Shivari can post these things with impunity because he benefits from the notoriety of the gang, and the prosecution doesn't even know if he's even posting it to a supposed enemy where he's gaining or using the impunity against, what evidence do we have? We have nothing. We have speculation. I asked Detective Collins, do you know the safety settings on Mr. Shivari's Facebook page? He said no. I said, do you know if his Facebook page is public or private? He didn't know. So we don't even know if Mr. Shivari's statements are going out to anybody or who they're going out to. I presume they're going out to somebody, but we have no idea who it's going out to. It could have been going out to just this group of people here. In the end, is the court familiar with Jackson Pollock, the painter?
Not personally, but
with his work. Okay. The way I've looked at this case, and I've tried to make sense of what the prosecution has been doing, they have literally taken a Jackson Pollock and seen the Mona Lisa in it by connecting disparate dots. And I submit to the court, Your Honor, that you can't go back and extrapolate and say that a person is guilty of a crime when they don't even know that the crime is going to be committed. And therein lies a fundamental issue with the problem of 182.5 and how the prosecution has interpreted it. They interpret it as, if you are a member of a gang and you know that the gang commits crimes in general, and you do anything to promote the gang itself, not necessarily a specific crime, then if you benefit or willfully promote it or talk about it, you're guilty. Under that theory, everybody in that picture from 5'9" Grimday should be in this courtroom because they all benefited from the notoriety of this gang.
Well, let's assume that that's true. Everybody should be. The fact that they're not, how does that help you?
Your Honor, the fact that they're not is the problem with this case, because that's where 182.5 and the prosecution's theory runs into other constitutional protections, which are, first of all, freedom of association. You're prosecuting them for associating as gang members without any other cogent benefit that can be proven, and it also runs smack dab into freedom of speech. And the chilling effect that the prosecution is going to have, and the risk that we run, that the prosecution now has an arbitrary means of prosecuting people for what they say, regardless of what they intended. And correct me if I'm wrong, but I believe that our justice system is based on the fact that you are prosecuted and convicted and punished when you commit an act and you knowingly commit that act that is criminal in nature. And therein lies the issue. You don't have to know, according to their theory, that a crime is going to be committed. You don't even have to know about the crime. If these 8 gentlemen are all together in a room and call themselves 5'9" Brent, or call themselves AT&T, or call themselves whatever they want to call them, because according to them, the nomenclature of Tiny Hit Squad, apparently you're supposed to take a literal meaning to that. So let's call them Tiny Hit Squad. And one of them goes out. The rest go about their business, which is promoting their music, promoting their videos. By the way, a video that Mr. Simmons referred to, which was a video where somebody gets punched and falls to the ground, which Detective Collins, during his testimony, said he could not testify for sure as to whether that was fake or that was real. These others are promoting their interests in a culture, in a gang rap culture. One of them goes out to commit a crime without the knowledge of the others that he's going to commit the crime, because he sang about it, he wrote about it, and he was happy about it, they're all guilty for a crime that somebody else committed. That's their theory. I submit to you, Your Honor, that we need to have greater specificity in not only the evidence, but also in how we look at the statute. I don't believe that we need to have specific intent written in the statute, but I do believe that willfully requires knowledge. That you knowingly promote, further, or assist a felony that you know is going to happen, or that you knowingly benefit from that felony. And I asked Detective Collins, how has Mr. Shivari benefited? He said, well, he benefits because he's a gang. He's in the gang. Well, how is that a benefit? Well, because he gets notoriety. Okay. I asked him, has he gotten a specifics? Has he received better service at a restaurant? No. Has anybody been taking care of his mom due to his notoriety while he's in custody? No, didn't know that. So, according to the prosecution theory, membership has its privileges, but they can't, that's all they say, privileges. Judge Frazier kept getting hung up on the issue of, well, is it a tangible benefit or an intangible benefit? Your Honor, if you're going to prosecute somebody for gaining a benefit, I think you have to point to a specific instance of gaining that benefit, not just, you're part of the gang, whether you know it or not, commits crimes, therefore you benefit. How is that a benefit? You don't even have a benefit. Your lifestyle is not any better. Your reputation isn't any better. Your monetary situation isn't any better. Your welfare isn't any better. So where's the benefit? Not like you can walk with impunity somewhere else in San Diego and come out unscathed. Quite the contrary. Based on the people's evidence, Your Honor, based on a fair reading of the statute, based on our system of justice where you have to hold somebody accountable for knowingly committing a crime or knowingly agree to commit a specific crime or helping somebody else commit a crime that you both know about. There's been no evidence in this preliminary hearing or in the preliminary hearing that was heard before Judge Frazier that would be sufficient to bind Mr. Shivari to any knowledge of any of the underlying crimes or willfully benefiting from any of the underlying crimes. If I can leave the court with one final analogy, if we go back to our early days of astrology where people would look at the heavens and they would see lions and tigers and bears, the only reason you see them is because that's how you interpret all these disparate points. But it doesn't mean that they're there just because you think they are. With that, Your Honor, I ask the court to discharge Mr. Shivari in each and every count because the people have not proven it to the sufficiency of evidence necessary to bind this man to answer for the charges. Thank you.